I was like, I apparently took over your channel somehow. That was good.
You know what happened? I as soon as I'm like, go live, check YouTube, and the next thing I know, my power just like blanked out. So I'm like, what the fuck? So I literally have to now put everything back.
Nate, I have a beef with you now, because when you dropped out, it reverted to just me on screen, and so it was just me staring blankly at YouTube for about 3 minutes solid while the chat was saying, please talk, but I didn't see it because I was waiting to be introduced. So it was me grinning like an idiot for about 3 minutes solid because you dropped out. Because you're like, well, I'm going to introduce you.
Yeah, that's what I said. Like, I want to introduce you.
Well, just sad.
Everybody should know who you are. This is UnCivil Law. This is my brother-in-law. How do you like that? Do you like the brother-in-law thing? I kind of came up with that on the fly. Brother-in-law. Yeah. It doesn't work. What's going on, everybody? Yeah, my luck. Christina, RC, Heretic, what's going on? I have to give saying hello to my people in the side chat. Let me go on to YouTube so I can at least see what's going on in the chat box while we're doing this. So today, guys, we are doing the MxR Play extortion scandal. So for all of you who don't know, I'm going to get into it in a second. Just let me pull up the live screen. You know what? Have you ever heard that saying? If no one, what is it? Mike Tyson, he says everybody has a plan till they got hit. Well, that's exactly what happened here. I had a plan, and then I got punched in the face. I'm like, what the fuck happened? I think it's because I left this iron on because I was ironing, and when I flipped on the fucking overhead lights, it's just too much power. All right. So today, let's start with a little background of what's been going on. All right. So there's a company called Junkin Media. Now, Junkin Media, what they do, their business model is they kind of scour the internet for viral videos. And what they do is their business model is to take a license to the viral video and then be able to help protect it for the creator of that content. So what they'll do is they'll scour, YouTube and all these other places to see if people are, infringing on this copyright. So, that's what they do. That's kind of what they do. And they I think they also maybe sell it or do whatever to help the creator make money. So, for instance, like, remember that there was the one with I think we were talking about it earlier with the Apple, when you open up the Apple box and how the phone's always at the top and it flips out. So there was a viral video like that they got. One of the interesting things is that so they go on and they either strike the videos if they're on YouTube, or they'll do the copyright strike where they could collect all the money. So there's this channel called MxR Plays, and MxR Plays. What they do is they're a clip show video. If you watch my channel, I know a lot of you guys who watch my channel know that I do reaction videos. So, like, let's say for instance, when I do a trailer, like if you go look at my channel, you see I have that one for Star Trek Picard. It got like 3,000 views, and it's like, as soon as I uploaded that video, it was, copyright, we're taking all that revenue. So they took all the revenue from every view that came from that. And that's what they do. I don't get a strike, but they take the revenue. And that's generally the way it goes. And if you have, multiple clips, they split the revenue. So Junkin was doing that to this channel, MxR Plays. Am I getting it right? Yep. Is that kind of the way you've been seeing it?
No, that's right. MxR plays a whole bunch of clips. Some of these clips are owned by Junkin. Junkin has their bots running in the background to see whether or not there's any infringing stuff out there. They find at least 4 videos of MxR Plays that have a clip that belongs to Junkin and send them a bill.
Yeah, now it's interesting because if you look at the MxR Plays video, which I got to put in the description, but MxR Plays, this is not like the first time they've dealt with this company. They actually paid them before. They paid them $2,000 in the past because they had done the same thing for their videos, and what happens is that Junkin says, okay, well, if you're going to use our stuff, you're going to pay us $1,500 per video. So they paid in the past, and Junkin was like, hey, we found 4 more of our videos. Here's a bill for 4 more, $6 grand. We found 4 times. So that's where we're at now. So MxR plays is more or less saying that's extortion. You know, if you don't pay us this $6,000 for these videos, for us, you know, if you don't pay us the $6,000, then we're going to strike your channel on YouTube and get your channel destroyed. Now they have like 800,000 subscribers, and this is like their main source of income. So this is very, very serious to them. This is serious to their way of life. And you know, MxR's position is hey, it's our copyright. If you want to use it, you got to pay us for it. So what do you think about the story so far, UnCivil? Have I missed anything?
Well, the one thing that I think is like the biggest disconnect that I can see in copyright law as it applies to other kinds of field of law is, let's suppose that you have an item at your house and on your front yard, it's a statue maybe, and you're selling for $250, you know, you've advertised it or whatever, and you've got a sign. And then I, negligently operate my car and destroy your statue. Now, one would presume that your damages are $250 because, you know, that's the value you've placed on it. You know, it's been open in the market for that. That's the price you've established for this thing. And so, assuming that's a commercially reasonable price, I'm probably liable for $250. Here's where I think the thing is breaking down for a lot of people. Jokin Media has said these clips are worth $49 each if you buy them in advance. So what a lot of people are saying is, well, wait a second, your damage for this, you know, tortious taking, right? Because it's not contract, therefore it must be tort. Your damage for this tortious and proper taking must be $49 because that's the value you've put on it. And even if you want to say like there should be some sort of multiplier as a punitive, you know, the idea of a 30x multiplier is breaking a lot of people's brains. So that's the sort of thing where I think this is breaking down for a lot of people, and I see that point.
No, I agree with you 110%. I think when it comes to it's to me, I think I don't want to put blame on either side. You know what I'm saying? Because one of the for any copyrighted attorney will tell you, one of the most difficult things to just ascertain is fair use. You know, fair use is like a minefield of problems. You know what I mean? So I'm trying to understand.
Yeah, but I'm just even blowing past that. I'm blowing past all those issues. I'm assuming that they own the copyright. I'm assuming it's not fair use, and I'm going straight to the damages issue. And the damages seem so disproportionate to a lot of people. I think this is where a lot of people are like, wait a second, something doesn't add up here.
Well, I would ask you this. Let's say, for instance, someone says, in your statue example, someone says, you know, I want to put the statue there. And you're right. Maybe the market value to do that is $250 or whatever. But is it not true that I can charge you however much I want? Like for me, that might just be, I might say, well, you know, if you want to leave it on my property, it's $1,000. You know, would that be wrong?
No, but by the same token of that, if we were going to like the real world example of, you know, thing in your yard and you sued me because I damaged your whatever, you know, you'd put a value on that and a jury would presumably assign the value that would make you whole.
Yeah.
You know, assuming it was simple negligence, there's not a reason to file punitive damages against me because we want to make you whole. I've injured you by, you know, ramming my car through your house maybe. But, you know, whatever the amount is to make you whole is the amount that you would get back, not some extra on top of that normally. That's
true. But it's interesting because I definitely understand that the damages out of litigation. But usually we don't price model things on you know, like say if the value that that it is for me may be different than what I'll get for damages. And even with junk in media, like, well, first let's deal with the issue of, is this extortion? Do you agree? Because some people are saying it is, and some people are saying it's not. Do you agree that, you know? How do you feel about the extortion? Because I don't believe this is extortion. I think it's close, but it's not extortion.
So what I actually saw from Jokin Media was the bill where they itemized each item, and it was titled something like, in the words of settlement was the language. It was junk and metal settlement fees, and at least that I saw on the graphic that was posted, I didn't see anything in that bill that said that if you don't do this, X is going to happen. Now, that might have been in some other communication, but I haven't seen language from Junkin in anything that was posted directly from them that says, here are some repercussions if you don't. Now that might have been communicated in the past in some way, but I would say, so first, my first thought is I'd want to know the exact language to answer that question. The second thing I'd say is, to the extent that what they're saying that would happen is legal things that they could do, I'd say it's not extortion. It's like, to go to my car has damaged something on your yard, you can say, pay me X, or I'm going to sue you, for the damages instead. And that would be not considered extortion because I've damaged you.
Mhm.
And so I have to pay compensation. So if what they're saying is, pay this amount or we're going to go file a lawsuit, pay this amount or we're going to file a strike, to the extent that they can do those things legally, those are probably okay.
Now,
I would imagine.
Now, to help the viewers out there, what I mean by extortion, now this is coming. It's different, I think, in the federal context and in the state context. But what I mean by extortion is extortion plainly means that you're threatening someone with some action if they don't pay you, and that's the simplest form of extortion. But there's a lot more to it, because the best example is the mob protection racket. Like the mobster comes into your store and tells the store owner, "Hey, listen, you need protection. So if you want, you need protection, you got to pay me X amount of money per month, or else something bad can happen to the store. It'll get burnt down. It's a rough neighborhood, that type of thing." And that's generally the most people, when they talk about extortion, that's what you're thinking about. You're thinking about two guys and, two mobsters going into the store telling you got to give me something for nothing. You know what I'm saying? The protection, the classic protection racket. But it's funny because I always use the example of, let's say you go into a store as a customer, and you go into the store and you shoplift. So you actually shoplift, put something in your pocket, and you're walking out the store. So you've stolen something, you put it in your pocket, and you're about to walk out, and you're stopped by the store manager. And he says, "Hey, you've stolen something, you're caught red-handed. I'm either pay for the item or I'm going to call the cops." Now that situation, I wouldn't consider extortion, because the person has been caught doing something. You have my property, and I'm saying to resolve it, I can give you, I can either call the cops and put you in jail, or I can be the nice guy and you just pay for it and then leave. That's kind of what I'm seeing what Junkin is doing here. But I do see the fact that Junkin, instead of paying, let's say if the item only really costs $10, they'll say, "Give me $100 for that item." Now we're talking about extortion.
Yeah,
pay for
that's where I think this is exactly breaking down, Nate. That was my point earlier. Mm-hmm. So you go into the store, you shoplift a $3 candy bar, give me $3 seems reasonable.
Yeah.
Give me $900, which would be the multiplier here, because it's a 30-to-1 multiplier. Give me $900 seems a lot less reasonable, because you haven't been harmed to the tune of, I have tortiously taken your property. I have improperly acquired it, and you want some sort of compensation. So it's like, well, that's fine. You have a right to seek redress, whatever form that comes in. You can say, "I want replevin, I want my candy bar back." You can say, "I want compensation for it. I want you to give me money for it." But beyond being compensated for the cost, and that's where I think this is breaking down, is like, where are you coming up with this number, 1,500?
Yeah,
that's a reasonable question. Where are you coming up with this number?
Well, that number's in the contract.
If $49 each, then like,
no, the in the contract they have, Junkin Media has with the copyright owner, the penalty for someone who does it is who takes it's $1,500. So they have a contractual agreement with the copyright owner that if somebody does do it, the penalty would be $1,500. So they're actually stuck in a contract to charge that much if you do it. But I think you're right. I think it's from $49 to $1,500 is huge. But that's what I think they'll leak their hand on.
Yeah. So if we just look at it to use a legal word, if we look at it as conversion, which is what we call it when we're talking about theft, except not criminally. So if I want to say, well, I stole something, but I don't want to use a criminal term, conversion is the word I would use. So it's like, well, I've converted this piece of intellectual property into my own, converted the candy bar into my own. And so either way, it's like you want to be compensated, seems reasonable. Yeah. You want to, I mean, the contract that you allude to, or you mention is kind of a false constraint, because they're the ones that put themselves in that box in the first place, right? They're the ones that say we will seek X dollars. So it's like, well, you said that, but you're the one who came up with it in the first place. Especially when the item, according to you, is $49 a go. Now, like, I can understand a rationale even for, we want something in terms of getting for every person we don't catch, or we want some sort of to compensate for all of it. So we're gonna distribute the entire pool of things that are stolen against all the people we catch, and so you're responsible part and parcel for everything everyone has stolen, because we were able to catch you. So I guess the analogy there would be a whole bunch of people go into a store and rob a candy bar, they catch you, and they want to get the entire crew's stuff out of you. At least that's kind of like plausible, because you were a snowflake in the avalanche, and therefore maybe we'll blame you for the whole thing.
Conspiracy, because you charged. Because
I wasn't necessarily suggesting it was a conspiracy. Even I was suggesting that 200 people, for no particular reason, at random and uncoordinated, all go into a shop at the exact same time and take candy bars for no particular reason, and then what?
It's funny. There's a case that's in Jersey, maybe like a month ago, right? Now, it's a funny case. Well, it's not funny. It's not a funny case, but it made me think about this. Now, they charged the store owner with extortion. What happens is a young woman goes into the store, an attractive young woman, and she steals something like, I think it was like a Rolex or something, a high value item, something like $10,000. And obviously she couldn't pay for it. So the store owner is like, you pay for it or we're going to call the cops. She couldn't pay for it. So they were like, we're going to call the cops. So he said, okay, well, if you give me a blowjob, then I won't call the cops. So obviously, and she did it. She gave him a blowjob. And after she got out, she went and reported it to the police, and they arrested him, and they charged him with extortion. And it's something exactly what we're talking about, where, even though I know it's a horrible example, but it's exactly what we're talking about here. What he was asking for was so out of the realm of what was normal. If he just said, let's pay for it, that's one thing. But asking for sexual favors, it's just something so obscene and so outside, it's not reasonable.
Yeah, and the answer to the problem that we've been illuminating is the statute that sets out these statutory damages, because we could say, well, you have to prove damages or something, what else? But what Congress, in its infinite wisdom, lest we question them, what Congress in its infinite wisdom said is, these candy bars have a minimum value of $300 and a maximum value of $150,000. They're somewhere in that number. We don't know how much they're worth. We're not going to bother asking. We're not going to bother asking how much you paid for them. We're not going to bother asking how much you normally sell them for. All candy bars are worth somewhere between $300 and $150,000. And so that's like the problem where this is breaking down, because Congress made a boo-boo. Congress made a boo-boo in the statutory damages by having them completely unpinned anything resembling a reality. So this is Congress's fault.
Hey, they need, Congress can't really do anything now, so it's not like this is going to be fixed anytime soon. And the thing is, with fair use, it's not with fair use, and with this particular, when it comes to copyright, it just hasn't been updated for the digital age. It's still kind of back in the 90s and the 2000s. Yeah. And maybe one day they'll get to fixing it, but we have to deal with it what it is. So we would both agree that extortion isn't really the issue. This isn't really extortion, even though I think an argument could be made on both sides. Like, hey, you're charging this $1,500 that you're only charging $49 for. It's kind of outside of the realm here.
It feels like extortion, and probably would be extortion in other contexts. The reason it's not extortion is because Congress decided that these items, which have some sort of nebulous value, instead have this exact precise value. Where Congress came up with these numbers, who knows? Perhaps Disney came up with them, for all I know. But either way, it's like they're pinning it based on these numbers. So it's like, oh, this is a reasonable number because it's basically an artificial price, right? Yeah. Normally in the United States, we frown on the government setting a price for things, right? We don't really like it when the government says this item has this price. We normally believe in free market and the right of free exchange and concepts like that. But in copyright world, for some reason, Congress said, we're not going to do that. We have a free market, but we're going to say the price is between these limits that we've set up because reasons, and it's interstate commerce. And also we have authority under Article 1, Section 8, Clause 8, so we can do anything we want, so go away. So that's why we're in the situation that we're in.
The old, what is it called? I forget the name of the what's it called when Congress has the authority to write the law, but I know the state, because I know we had there was one time when I was at DA's office, we had an extortion case that we were dealing with, and it was written, the law was written in such a way where the federal government had the authority to prosecute it, but they were able to kind of remove our authority to prosecute it because it was like a federal. You know what?
You mean preemption?
Yes, preemption. Our law was preempted, but the law wasn't actually preempted. But we weren't going to enforce it because it was like a whole fucking mess. But anyway, it was similar to what you were saying. What I want to move to is that, okay, so we both agree that the extortion thing is a little bit overblown. It could be, could not be, but I'm leaning more toward it's not.
It's probably not, because the reason it's not extortion is because it's both lawful and reasonable. And the reason it's both lawful and reasonable is because Congress said so. And that's like where we can kind of stop that analysis, I think, on terms of that.
Now, the second part that people have been saying is that the striking of the channel. Okay, so even if you had this copyright claim, you can then go sue, but then why go strike the channel? Because striking the channel will just remove it from YouTube and the whole this thing. So people are saying that piece of it, that that you're going to destroy the channel, is also the secondary extortion part of it. Yeah. And to that, I'm going to say is if they have the legal, you're saying they have the legal right to do it, and it's reasonable. They've done it before to other channels. They've done it before to that channel. So is it extortion if you're using my stuff, pay me for it, or I'm going to give you a strike? I think that's reasonable.
Yeah, and again, this is part of the problem under the Digital Millennium Copyright Act is one of the things that allows them to do this. When you have repeated offenders, and we've seen cases come up with this, with Cox, I think, got really burned on this because they had knowledge of a particular consumer who used like way too much stuff and didn't do anything in order to take them down. But yeah, so the policy of YouTube is responding to the law. It's like you've got to, if someone's a repeated offender, I forget the exact language, you got to take away their access. And so YouTube is, in their infinite wisdom, has decided on this 3 strikes. I don't know that that's required exactly, but some number of strikes is. And so Jukin could presumably give them at least 1 strike, presumably for the content if they wanted to. And if it would be the equivalent of, to go back to the candy bar, because why not? I want my money and I'm going to call the police. So you have both civil and criminal liability. So here it's like double civil liability, but you have liability to me, the copyright holder, and you also have civil liability effectively to the government, who's the one who's imposing this requirement on YouTube to ban repeated malicious users.
Now, my question to you, what do you think about the fact that MxR paid this, I was about to call it extortion, but they paid this fee in the past. They paid because they said, yes, we used your stuff. Yes, and we've paid this fee in the past. Would that be something that you would consider in Junkin's favor, the saying, hey, we had now this relationship where they they admit they were using our stuff. They admit that they didn't have permission, and they paid us this fee in the past. So we're just now continuing the same business practice. Hey, you guys have 4 more videos. Here's 4 more, here's 4 more invoices.
And if you want to be Jukin's lawyer, and by the way, Jukin, if you need lawyers, hook me up. I'm happy. Yeah, you guys obviously have money, so give me a call. But yeah, if you want to do this from Jukin's point of view, you can even say, to the extent we've asked for more money than we did in the past, we did it specifically because we have tried to be nicer and ask for less money in the past in the hope they would get the point. They apparently haven't gotten the point. So we are gradually increasing the temperature of this thing as part of our efforts to not go all the way from 0 to 60, and just say we're increasing the fine because we want them to stop doing it. And so maybe if we increase it a little bit more, they'll stop this time. And so that would be what Jukin's arguments. We've charged them in the past, even when we charged them lower amounts in the past, they obviously didn't get the point. So now we're going to charge them more and hope that, they'll respect our IP now. That'd be nice.
Well, and let's think about what they've done in the past. And this is from MxR Plays video. They said first they did the old, they give them a copyright strike, but they just took the income. All right, we're going to strike the video, but we'll take the income. That's the first thing. Then the second thing was, okay, well, now we're going to give you actual strike and now send you the invoice. Then the second thing is, okay, you've paid the $1,000 invoice and you kept doing it, so we gave you another invoice for a higher amount. So I definitely agree with the whole graduation of harm. But now I think you get to the point where it's difficult, because I think in the legal arena, I think Jukin has really good legs to stand on. But I think in the public opinion arena, I think they got a problem.
Yeah, Jukin's losing the PR battle.
Yeah, I think that's the problem. And with words like extortion, big company, and then when you watch MxR's video, they're crying. The girl's crying. I told them to look through the videos. It's just like, it made me feel sad. I'm like, damn, this evil company. Stop them. But the fact of the matter is they admit that they were using Jukin's copyrighted material without permission. That is just what happened. You know what I mean?
Yeah, I mean, that's exactly one of the arguments from Jukins. Like, we can show actual knowledge from them in the past because we've informed them of in the past, and they keep doing it. And so, like, we haven't gone into the fair use issue, which, of course, if this is fair use, then all this becomes moot because they have the right to do it, not paying a fee. So we've been making various assumptions up at this point. We were assuming that Jukins owns the copyright. We're assuming there's no fair use.
I think he froze out on me.
But yeah, assuming there's no fair use, it's like, well, we told them in the past, and they had actual knowledge in the past. We keep trying to get them to stop, and they keep doing it. And so, we need to put amount out there to get them to stop, and we're going to keep increasing the fine until they do, within the limits of the law. And so, we just want our copyright to be respected. I don't know how you swing that into a PR statement. I do law, less PR. So, you can take that legal message and run it through the PR filter a couple times and see what the PR people can come up with.
I always laugh at the fact that the simplest thing when we let's take all the emotions out of this thing. This is a very simple thing. Someone has taken someone else's material and used it as their own to make money. That's the simplest thing that you can say about this. And now the piece about it is whether the reaction of them saying, give us $1,500 for using this $49 video is reasonable. And that's the first piece. But I also think the second piece of this now is the fair use piece that we're about to get into. So, and I'll just give my assessment. They got a lot of watch hours for me, because I watched maybe about 2 hours of MxR's videos and their clip show. And one thing that I did like is that some of the videos they use seem to be fair use, and some of the videos seem not to be fair use, because of some of the videos they just played. You saw the whole thing begin, and they laugh about it at the end and say something at the end. But the other videos they played, and then they were doing the commentary. And I forgot the other case that MxR, because I watched it in French's video. French did the breakdown of their case, and it was kind of that same thing. Like, one of the videos wasn't fair use, but the other videos were clearly fair use. So now in a situation like that, since there's obviously I haven't watched the video, so I don't know if it's fair use or not. What would be do you believe? Well, I'm just trying to figure out how to ask this question. What do you think about the fair use argument?
Well, there was language. I was trying to find the exact language from the case while you were talking, and I didn't quite get to it, because in the H3 case, the Elon Klein case that was the big landmark case that was established, there was a footnote from the judge in that case, and basically said, I'm going to paraphrase it, but basically said that this is part of the H3 videos are part of a larger genre that might be called reaction channels. And some of these are more like group watch parties with minimal interaction. And some are more with, commentary, critique, blah, blah, blah. H3 is more of the latter case. And the court is not saying that all reaction videos are therefore fair use. So that's a pretty reasonable paraphrase of what the court said. Basically said, look, in the H3H3 Elon Klein case and Hila Klein case, that what they were doing was taking exact videos and reacting to it and providing critique, commentary, biting remarks, mocking, all the good stuff that we love and enjoy.
Mhm.
So one could make a credible argument that in the Juke and Media case and the MxR Plays case, that it's more, especially with respect to the video clips in question, that it's more of the former, of more just a watching party without substantive commentary. Now, in one of those videos, it was argued that there was less commentary than there might have otherwise been, because the video that came immediately before them, that one, was of an upsetting nature, and therefore they were emotionally distracted from providing other commentary. But that would be like the argument where on that gamut it goes. I also read the previous case with Juke and Media and the previous decisions there that were discussing this exact issue in terms of how much reaction and how much additional stuff is being added to that mix. And in that case with Juke and Media, it read more like the H3H3 case. This case feels not quite in that same category. This case feels more favorable to Juke and Media. I think Juke and Media has a much better argument that this is not fair use, at least for some of these clips.
Hold up, for Viva, if you check your email, I just sent you the link. So if you want to get inside here and rumble in the jungle with us, you got the link. So the link is it. Check your email. It's in the email. You can definitely come on in.
Oh yeah, no, I'd love to have you, Viva. Yeah.
But so it's interesting because the fair use factors are. This is probably why I hate copyright law. No offense to you patent and copyright attorneys, but that shit is just crazy,
Yeah, that's Leonard's problem. Patent
that's
law.
Leonard.
Well, it's great because in patent law we have a 0-factor fair use analysis. It's really simple.
Oh, what is it? I'm interested.
There isn't fair use.
Oh, you said 0-factor. I'm like, oh, what is it? Elements? So now I'm interested. Oh, okay. I hate you now with this patent attorney. You don't have to worry about this. So now. So we both agree that fair use may apply, and we also both agree that it's really not extortion. So now, what do you think? What should, if we were looking at it, like my thoughts about this is that you got to call somebody's bluff, especially if you got 800,000 subscribers. If you're paying $2,000, fines and $6,000 invoices, that's enough to you can put somebody on a retainer, and have this figured out, because you got to call their bluff. You got to call their bluff at this time. And I know it may be a little bit more expensive. It's easy for me to say because I'm not going to go to court, but that's just how it kind of works, or you got to be more careful. One of the craziest things that they said was what MxR said was, she said that she asked them to go through their old videos to see if they were using that
was not a reasonable request. I understand why she thought it was a reasonable request. I understand why she was really upset that Juke and Media said no. First of all, I don't know if they actually said no or just ignored it completely. Probably the latter, if I had to guess.
Yeah, I wouldn't respond.
But it's a problem for a whole number of levels. It's like basically you want us to give you a pass. That's a lot of work from us on the front end. Heaven forbid we miss anything on the first time, and then we've basically infringed our own client's copyright. So that's super fun by giving you an immunity for something you shouldn't have. But yeah, it wasn't a reasonable request. And Juke and Media is almost certainly not reviewing these things manually. At least at first, they've got a bot running, and maybe we should just have some Juke and Media clips on screen right now, just for no particular reason on the screen, and that could be part of our meta commentary about the whole thing. Let me tell you what I really think by displaying this image. That's what I think. Haha.
You kind of get them after me. No. I'm not gonna, because I'll have to do a video. Juke and Media's after me. They hit $1,500. No, that's not.
Let's interview the Juke and Media clip itself. Juke and Media clip. What's your opinion about it?
All right, here we go. We got another lawyer. How many lawyers do we need to do with a live stream like this? We got Viva Frei. What's going on, Viva?
How you guys doing?
Hey, good to see you, man.
I'm tweeting this out. I'm going to see if we can get Leonard French in.
Oh yeah, no, I'm down. No, I'm down. Absolutely.
The
This
four
is great.
horsemen. The four
No,
horsemen.
this is the greatest stream ever. except for the 3 minutes when he had me staring into the camera, muted, and everyone was watching just me because Nate's Wi-Fi dropped out.
That was more.
It was
more
not
than 3
so
minutes.
great then.
That was a good 10 minutes, I tell you.
Oh my god! No, you know what happens? I was ironing because I did laundry today, and I was ironing, and I forgot to, and I put the iron up, and I forgot to turn the iron on. So when I turned on the lights and stuff, my what's it called? The circuit breaker switched.
Leonard says he's in.
Oh, all right.
Oh my god!
Send the link.
This is
Can I just send the link you sent me from earlier?
Yeah, it'll work.
this is
All
the
right, good.
Brody Bunch.
The Brody Bunch. So I'm like sitting here. It's funny because I'm sitting here. I'm like, the house is all dark, and you know me, dark skin, so it's like I'm in shadow mode here. So I got to go flip on the lights and turn everything back on and turn the computer back on. I'm like, oh my god, this is fucking crazy. So, I just said the bad word.
Don't wait. Whose channel? This is streaming on your channel, Nate.
Yeah, this is me. This is
Okay,
me.
so you'll get the problem with YouTube.
And Junkin, they're like they said our name 4 times. Send them a bill. Send that guy a bill. So go ahead.
Here's my 2 cents on the extortion thing. First of all, Nate, I do wonder, I haven't looked into the case law. I do wonder if, technically speaking, the shop owner says, buy it or I'm going to file criminal charges. I do wonder if there isn't case law on that. I'd be curious to know. But I said it in my videos, like threatening legitimate civil remedies is not extortion. Where it gets borderline is when you start threatening statutory complaints for failure to pay a civil settlement. Threatening to file the DMCA takedown, I mean, I think it gets very close to filing a statutory complaint, an unrelated statutory complaint to the amount claimed to coerce a civil settlement. If I'm Jukin's lawyer, I'm telling them not to do it just because it walks a line they may not want to walk. And then, flipping it around, if I'm MxR's lawyer, I'm telling them not to use certain words because words have meanings. Even if you're angry and upset, you have to bite your tongue sometimes and weigh your words.
Yeah. Yeah, but what do you think about the example that we said about the candy bar? If someone goes into a store, steals a candy bar, and it gets caught, and they say, "Well, pay for the candy bar, or else, or we're going to have to call the police," and they pay, and the guy says, "Okay, how much is the candy bar?" And the guy says $5,000. That would we say that's classic extortion. No?
Yeah, I think even like pay for it or I call the police, we're getting there. Pay 10 times more, then I think we may have crossed the line, but. The whole thing about paying the $1,500, let's take it in an abstract. If they're my client and they come to me and they say, someone just sent me this invoice for $1,500 for unauthorized use, I'm telling them not to pay it, period. Yeah, don't pay it, let them sue you. Where it becomes the problem is they say, okay, well, if I don't pay it, they're not going to sue me. They're going to do something worse. They're going to give me a strike and shut my channel down. And then it's a question of still not paying for it. Like, screw you, I don't owe you $1,500. We can talk about what I might owe you, but let's sit down and talk. I think the problem is just trying to resolve these problems on their own. It oftentimes makes them messier than when they were before.
I'd be interested to know how much that library license apparently that they're offering would cost, because one of the things they said is we'll give you a access to our entire library. I want to know if that's more or less than $6,000, because can I just pay for that and get your entire library and back end now?
Well, guaranteed it's less. By the looks of it, it's $49 a month, or it might be $49 per video. I'm not.
Yeah, I think that's per video, because I understand it.
But bottom line is obviously this is technology at its finest.
Thank you, StreamYard. What's going on, Leonard French? How you doing?
Maybe Leonard is not
he might be on mute
or something.
Yeah, there we go.
All right,
everything's set up.
Yeah.
Needed to mute the YouTube.
And Leonard, of course, is talking to us from Luxembourg. So thank you, Leonard.
What are you doing in Luxembourg?
Oh, my fiance lives in Luxembourg, and someday soon I might live in Luxembourg.
Is this like a 90-day fiance thing? Because my wife is like addicted to 90-day fiance.
No, we met about 2 years ago through the channel, actually. It's a great love story.
You got to tell that one day. Oh my God.
Yeah. So I don't know Nate. So who is Nate? Are you another attorney or?
Yes, I'm
excellent.
I'm an attorney from New York. I used to be a ADA. I taught at a law school for 2 years. So I was a law school
ADA, wow.
Yeah,
excellent.
I was
very nice to meet you.
I was a cop for about 11 years. So.
Oh,
by the way, since only wish me a happy birthday today.
So you
is my
took a
birthday,
pay
so
cut to
say
become an
birthday.
attorney.
yes. You know what? Most people don't realize that. Yes, it was funny because when I was a cop, I was making more money than when I.
Yeah,
it was
better
funny.
pension too.
Yes. Oh my God. Oh, you don't know. You don't know.
Leonard, if you want to know everything about Nate, check out our first live stream where I think we spent about an hour going over Nate's entire story from beginning to present, and it was amazing.
I will look for it.
This is the first time I've ever had like 4 actual attorneys in the room. It's like I'm nervous now. I don't know what to say.
Great.
You know, I'm like scared to death. I'm about to play a juking video like the whole way through and let them destroy us and see what happens. Do you think they'll have the balls to strike us?
In each box, it doesn't count, right?
I don't know. I have a feeling this is more highly transformative than MxR's video.
So what do you think about the whole? Because I've watched the videos and I got to say that they are great. You and Viva like break everything down so easily. It's funny because I'm almost afraid to do a video and I'm like, damn, they've already said it all. But
well, try to give me a topic that I'm not familiar with, like something that's not copyright law, and then I'll sound like an idiot.
So in this particular sphere, what do you think about the extortion piece? Because that seems to be the piece that's riling everybody out. Extortion.
Yeah, I don't. That's the part I don't like. Is if they were really making a threat of striking the channel, so they know that YouTube strikes channels for DMCA takedowns, and instead of just going after the money, the dispute's really over the money. Come on, why would you threaten somebody's livelihood, even if it's legal to do so? We still, as attorneys, I think, have some kind of duty to consider the consequences of our actions and how they're going to make the whole profession look. And even though I know that doesn't necessarily mean that anybody has a legal claim, or you can even make a grievance against an attorney for being aggressive, it's still just that it rubs me the wrong way. I don't think that that's a good representation of what we want out of the law. It doesn't advance the sciences and the useful arts, as the Constitution says.
Go ahead. Somebody, you were saying something?
I was going to say one thing, Leonard. The extortion part, okay, fine. I don't think they're going after them for the money. I think they're just going after them to stop doing it. But one of the facts that is, and I say stop doing it after, by MxR's account, months of doing it, months of getting claimed and still keep doing it. Then the strikes came and they still keep doing it. One fact there are 2 facts that seem to be unclear. When they paid the $1,500, was it for a license or was it for one of the previous violations?
I think it was just for one of the violations, for one license or one violation, not a blanket situation, not a ongoing relationship. But I don't know for sure.
Okay, and then the second question I had, and I think it's pretty clear to most, but the what was it called? E3, the H3H3 judgment. They made reference to the benefits of registering the copyright, and that relates to statutory damages that you can claim if it's registered versus only actual damages if the copyright is not registered, correct?
Yes, you still have to register the copyright now as a prerequisite to get into federal court. And it's not just the application, but the application has to be granted or denied, but that's a whole other series of events that I'm not even familiar with what happens if your copyright registration is denied. But you can't get into court even. You're not even allowed to file a suit that will survive a motion to dismiss if you don't have the copyright registered, which is about a 6-month waiting period right now. Ooh. So that it still preserves your right to sue, but if you registered your copyright late, you could have things rolling off of the 3-year statute of limitations while you're waiting to sue, and those will not count.
They don't toll it. They don't toll
it for the copyright registration, which is a weird result. I think Congress needs to fix that, is what the Supreme Court said.
And now I have a technical fair use question on this, on how it would be interpreted, and this might be a point of argument rather than a clear answer, because you have a whole bunch of videos, a whole bunch of clips in the same video, presumably from different copyright holders as well, and so you're reacting to a whole bunch of clips in a series of clips. So when I'm trying to look at the transformative aspect, to what degree, if any, am I looking at it piecemeal from each individual thing and saying, well, each individual thing is a piece of property under itself, whether or not it's owned by the same person or not. And so I need to find the fair use factors for each clip, because my understanding is one of the clips had essentially no reaction, but that was partly because of the clip that came before. and they were a little emotionally spent. So I'm trying to determine to the degree to which that's a relevant argument or not.
That's a really good question. I think that depends on whether you're a plaintiff's attorney or a defense attorney.
I think you're right too.
As a defense attorney, I'm going to be saying, "Oh no, it was just one segment of a much larger." And if I'm a plaintiff's attorney, I'm going to try to get the court to recognize it as a discrete segment.
No, I think you're 100% right. We were going to argue over whether or not we're talking about the forest or the trees, depending on what side of the argument we're on. Yeah, exactly.
Yeah, basically.
Even to chime in on this, even in the, I want to say it's H3H3, but what is the actual name? 3 Equity or E3?
Two different cases. Equals 3 versus Jukin Media is a 2016 fair use case that Jukin had, they counterclaimed against Equals 3. I haven't actually seen the Equals 3's videos. I just read through Equals 3's complaint or summary judgment finding opinion from the judge. So the judge found, what was it, like 2 of the videos did not infringe and 1 of them did, and I don't even know about the other 16 that were claimed. But then the jury ruled on it, and then that jury verdict was sealed because the parties settled. That's a different case than the H3H3 case, which was against Matthew Hossenjada or something like that. It's I don't even know how to pronounce it, so we just call him Matt Hoss. Okay, and so that was the quintessential fair use case.
I think so. It was in the one. It was in the first one where the judge determined that the use was highly transformative. I think it was in 3 of the 4 cases, and it was not fair use in 1 of the 4. And I mean, to answer uncivil laws, my take on it is it doesn't matter if the entire 10-minute episode is highly transformative to the extent that the video clip used is not transformative. There might be 15 clips used in a video, but if they use one in its entirety, there was no transformation to that. And I think that's what they addressed in that decision, where they said the use of the copyrighted work had text overlays. It replayed the same scene multiple times. They zoomed in, they zoomed out, they cut in, cut out, as opposed to reproducing one clip in its entirety in the episode. That won't fly. Leonard, if you know this answer, it's been bogging me down for a long time. If there are 10 separate violations by 10 separate copyright holders in one video, and all 10 make a claim to claim the monetization, how does that work on YouTube? Do they split it 10 ways?
So far, that's the copyright deadlock that Jim Sterling likes to talk about. And he uses that method to keep people from claiming his videos. They can claim the video, but then none of them get the revenue. As soon as a second claim comes in, nobody gets the revenue. As far as I know, that's the way it still works. Somebody can correct me. I don't play that game. I don't do that, so I don't know from firsthand experiment.
No, I'm wondering, nobody gets the revenue except for YouTube.
Except for YouTube. Yeah, exactly.
Let me show you guys something. I don't know if you guys have seen this new YouTube screen that they have up. Hold on, let me put this thing up. Let me share my screen real quick. But YouTube has this new application. I think they rolled out maybe last month. Where, can you guys see my screen?
Yep.
Yeah.
You see where it says channel copyright, and they give you this and tells you, like, all right, I did a video on my screen about like Ken Hovind, and they tell me like who's used it. Like this guy used 30% of my videos in their video, 30% of this, and this guy used, and this person used 100% of my video in their video. So they go in, so they tell you now where your video was used, if people are using it, and what you can do. So it's, and I can strike these videos for the part of the videos of mine that they used in it. So this is making it a little easier to find these copyright claims. You know what I mean?
Yeah, it'd be nice if I had the reverse of that. I know that Jukin won't do it for me, but it'd be nice if when I upload it to YouTube, we know YouTube has copyright bots in the background. And so it'd be nice if the bots would give it a once through and be like, well, we detected these uses. Are you sure they're fair use? To at least alert you to the fact there might be a problem. That'd be nice. Why not? Let's throw that in there.
That would be better to do the reverse, but and it's funny because that's what I think MxR was asking for. They're asking for the reverse. Hey, just check all our videos. But again, I don't have the, they're not gonna, they have to hire somebody to do that. So
it's one step beyond that. I mentioned it in the video. It's not just that it's not Jukin's job, but then it almost shifts the onus onto Jukin to make sure that MxR has copyright over their videos. And then if they don't, sure as sugar, if somebody else goes after MxR is going to say, but Jukin said it was okay. Now go after them. It's I won't say an irresponsible request. It's an unrealistic request, and it's not. It doesn't show good faith. It doesn't show bad faith. It's just such an unrealistic request from the beginning that it's not a serious request. Yeah. Whether or not Jukin can go and surf the net afterwards, they do that to save money. They do that as part of their business protection. They don't do that as a service to anybody who wants to license their videos. License the videos, pay whatever it is per video, and avoid any potential for issue. Everybody's saying it's fair use. It's fair use. Reaction videos walk a line. If you're walking the line more on one side than the other, an ounce of prevention is worth a pound of cure. License the video or don't use it, or find one that is cheaper, or find one that you can get permission for. Yeah.
But it's hard when you're a small channel and you don't have any money. Paying these fees can add up. It's funny because all the reaction videos I have, all of them monetized to the other people. I'm just so glad nobody's gave me a strike. But you run that risk, though. You run that risk if you're going to play that game. You run that risk, and I think MxR ran that risk. Even though I think Jukin is being overly dramatic with this invoice and all this crap, but you can do it for somebody who has 800,000 subscribers because they kind of have the money to pay. And I've always didn't understand if Jukin, why not just get the ad revenue? Especially it's because if they put up the video and they were getting something like hundreds of thousands of views on these videos, 300, 400,000 views on these videos. Why not just take the ad revenue? Because that's more money than even this $1,500. That's going to be more than the $1,500 they're getting anyway. No.
What if that copyright deadlock happened by accident, and because they're doing this, they did get other monetization claims, and so Jukin's not going to see any of that money?
That incidentally, like Leonard, for what you said is the option as to what happens when there's multiple claims. That seems to support your perspective, because my first reaction was they just claim it, and typically when it happens, I mean, I don't know typically, but oftentimes when a claimant will claim it, maybe it's just that video. There's only one reference to a copyrighted work, and they get all of the revenue. But if they're getting deadlocked out of any revenue splitting, it makes sense why they escalate up to the next step.
But then if they didn't register their copyrights, that also doesn't give them access to statutory damages, which means they're only going after $50 a video plus whatever attorney's fees. And I don't know if there's a trebling of damages for willful infringement, but even if it's $150 in a video, that's not a lot.
No, I think
that was what I was talking about with Nate earlier in the stream, where it's like if I went in and I took a candy bar from someone, we'd all say, well, that's a tortious wrong. I owe them for the cost of that bar.
Yeah.
But like the idea that I owe them for 30 times the cost of that candy bar doesn't seem to fly. If I drive my car negligently and damage something on your property, we can go to court to argue about how much damage there was. But the idea only is that I'm supposed to make you whole. I'm not supposed to give you a windfall beyond that. So the thing that I think is blowing a lot of people's minds here is that apparently these are $49 a clip. Normal price for you, my friend, special price. But if you're not my friend, it's $1,500 a clip on the back end, and it seems a little not in sync with how we would treat this if it were other kinds of property and other kinds of situation.
Well, I mean, not to compare Jukin's stake in the video licensing to the government, but there's a reason why the government penalties for not paying taxes or whatever are so excessive compared to what would otherwise be normal, because they want to. It's supposed to be the deterrent to stop people from doing it. If all that Jukin does after all this hassle is get their original $49, there's no deterring factor for MxR or for anybody else. So I have no doubt that this is done in part to scare the market out of, so people don't do this, and also to just to punish them in a sense, although I don't think they have to pay the amount, to scare them to stop doing it on a going forward basis.
You know what? Sorry, I didn't mean to step on you, Nate, but you know what blows my mind is we got 4 attorneys here at a fairly collectively high hourly rate who just love doing what we're doing so much. We're going to spend our time here.
I guarantee you I'm the cheapest, and I'm Canadian dollars, so I'm 30% cheaper.
Everybody hire Viva.
That's right.
But I think they don't need lawyers right now. They need just someone to sit both of them down and to discuss it, because it is funny. Like everybody's thinking that Jukin got scared off social media, so that's a sign of guilt, when I can reasonably anticipate what they've been dealing with in terms of harassment. Because when 800,000 people think that some big bad boogeyman is extorting your buddies, you react defensively. But
I don't know. I can kind of guarantee that Jukin's still doing okay on the back end. People are like, "Oh, yeah, look at the controversy they'll cause to enforce my copyright."
Well, and not just that, this is like there are now 800,000 people that know of Jukin.
Know who they are. I didn't know who they were.
There's probably
I
more
didn't
than
even remember the case till Legal pointed it out.
Because they know that they'll enforce their copyright for them and like, hey, this company really will protect me. Look at the good work they're doing protecting these people. I'm going to sign up with Jukin.
Well, so it's an interesting thing also because I put out my video on Saturday and follow up on Sunday, and I disclosed that I use these video licensing agencies. I don't use Jukin for whatever the reason, but everyone's like, well, he's a shill because he's working for the agencies. It's like, no, when I did viral videos before I did my direct, my law content, I did use them because I don't want to have to write an email to somebody saying you used my video, you used the entire thing in your montage. You didn't ask me, you didn't give credit, and you didn't give monetization. I don't want to have these discussions. So the very reason I use these agencies is so they can do the dirty work for me. It's good for the creator. It's obviously good for the company. But I think a lot of people think that Jukin does this for their own sole 100% benefit and don't fully appreciate that they're doing this to protect the rights of creators who have chosen to license it through Jukin or others.
Well, you know what? This reminds me of something that happened maybe about 3 or 4 years ago on YouTube. Like a lot of people were going to get free music, and when they had the free royalty-free music, you download it, you can use it royalty-free. But then someone was going and buying up those copyrights to that music, and then would go back and retroactively strike or get people who are using that music and say, okay, well, now you're using my music because now I have the license, so you have to now pay me to use it. So that was happening in the past, and that's kind of what I thought was happening here, where people are just going back and buying the copyright to these old videos and old music and old things, and then now coming forward and saying, okay, now you have to pay me money because I have the license. But that's, I think, was the big fear. I don't know how it's going to play out now because Jukin is obviously not doing that. But I do see scenarios, and people are scared for scenarios because a lot of my older videos that does have, I think, material in it that could be on the borderline. There's always that fear that somebody can come back 10 years later and say, hey, you owe us money because you've been using my copyright for the past 10 years.
So that was actually that's another one of the misconceptions that I think a lot of people in this MxR are under the impression that Jukin acquired the rights afterwards and then retroactively went after them. My understanding is that they didn't, but even if they didn't have the rights at the time MxR played it, MxR still didn't have the authorization from the copyright owner. And so then this is where it becomes a big impractical reality of the situation is even if I get authorization from Joe Schmo who owns it and then license it through another agency, the agency comes after me and I say, no, I got Joe Schmo's authorization. Here's the email. And they say, well, that's not good enough for us and we're going to go after you anyhow. This is where it's so insignificant, the amounts, but the consequences or the sanctions that can be so imposed are so great that there's a problem. The only question is how to address it via legislation. But there's a real problem. But there are varying interests in this that need to be protected.
In an election year, not gonna happen.
So
I believe your video, Viva, earlier was talking about the chilling effect aspect of this because certain people would not do certain things because they'd be borderline and would have a chilling effect from doing it. And the same problem with COPPA, which I suppose we could talk about that too. Why not at this point? But it's the whole thing. It's like the uncertainty breeds conservative behavior, breeds protectionist behavior. And so, there's a lot of people who are concerned about that, I think in the most global sense, this going from the Wild West days of the internet to even more and more corporates, branded TV, and where YouTube might be going in that direction is just, corporate branded, and something is being lost by that exchange.
Well, but there's two aspects to the chilling effect, right? There's the chilling effect on the genre of reaction videos. Sure, if this holds up, then reaction videos are going to not do reaction videos. My response to that is, or just license the videos. But then there's the flip side of the chilling effect is if reaction videos can just basically reproduce copyrighted work with impunity, the chilling effect is I'm not going to necessarily post my stuff on YouTube knowing that somebody else can go make a monetizable video off of my content without giving me any compensation for the work that I did. So there's two sides to the chilling effect. All that I know is that people do they put work into their videos or they capture moments that they are entitled to monetize. And these reaction videos in particular very much walk the line between entire reproduction with minimal transformative value for their own personal gain with no benefit to the creator versus those that transform it enough.
And then to throw that wrench into the works, the person who just happens to point their phone in the right direction and get a fun event on their phone isn't quite the same as a person who sets up a scene, plays with the lighting and the angle and the settings on the camera, even if it's just a phone camera, and tries to produce something. So even that's going to come into how much copyrightability is something. Did someone just record an event, or did someone create a scene or produce a movie or something like that?
Yeah, but I would take, but even with the people who just happen to point their phone in the right direction at the right time, and they have the video that everybody wants, that's the luck of the draw of being, quick fingered on your phone, is that you have a video that people want to buy, and you have a video that you want to license. You don't get to reproduce the whole thing just because you're reacting to it. I think the reaction genre in general is much more borderline than everything else. Yeah. People ask me, I suspect you guys get the same question, but like, oh, I used a piece from Legal Eagle, or I used a piece from MRX's video, well, people can come after me. And I say, well, first of all, I probably used less than 5% of the entire video. I used the bare essential, and I still understand that risk is there. I've just assessed the factors in my own head, and if anybody wants to come after me, it'll be abusive. I may contest it, I may not, but I know the risk is there. Versus these other channels that use the vast majority of the videos, and they laugh and they make jokes, and they think that that's sufficiently transformative, where it's a gray zone, and they don't appreciate that.
Yeah, I was just laughing in my head because I was like, well, what's the probability that this video that we're making right now will be the feature of some future reaction video from someone else? That which one of the four of us want to sue that person, I guess, is the question.
Well, then you've got
right?
DMCA 512F, which requires a knowing good faith belief that your either takedown is proper or your dispute of a takedown is proper. And both parties could be right in the sense that they both had a good faith belief. And so if they both have a sincere good faith belief, nobody gets damages from that. Nobody gets their attorney's fees paid for.
Well, so just attorney's fees, or not on damages for the infringement?
Well, so let's take the strikes and monetization claims and all that stuff out of this. If this is purely a DMCA takedown issue, and then someone issues a counter notification, 17 USC 512F says you only get misrepresentation damages for knowing good, or rather knowing not good faith misrepresentations. If you have a sincere good faith belief, which was the court's language, if you have a sincere good faith belief, which is provable. I actually had a case about this, and we went to mediation or arbitration, and we had to put on the evidence of what my client knew and when, and then the arbitrator decided that my client did have a sincere good faith belief, even though my client was wrong. My client was sincere and had a good faith belief. And the moment that he realized he was wrong, he immediately retracted his counter notification or his DMCA claim or whatever it was. And we actually got our fees paid for because they sued us and they were wrong.
Leonard, let me ask you, in that particular example, when your client realized he was he wrong on the fair use aspect, or was he wrong on the ownership of copyright aspect?
He was wrong on the fair use aspect. He thought that someone who had made a critical video of him, he thought that person that person had not made a fair use, and so he issued a DMCA takedown, and then they sued them for basically a declaratory judgment of non-infringement. I forget what the exact complaint was. The judge asked what the damages were, and I said about $12, and the judge laughed and called his secretary in and said, hey, could you bring in that pamphlet on arbitration and mediation for our parties here? And that was what we took to mean, you're going to do this, don't piss me off any further.
Well, and there's another aspect to this which is not necessarily in the law yet, but when someone uses, say, like 100% of one of Nate Brody's videos, someone can say reasonably that using the video, or using that video, 100% of it might be taking views away from that particular video, but Nate's brand and Nate's channel, it will definitely generate more interest to the channel as a whole, because Nate is a brand that goes beyond one video. And it's the difference between like branded content versus these one-off videos where people only get the revenue from that one video as it goes viral, as it gets licensed out. And so someone can take 100% of my channel and review it on their channel and be critical, insert whatever. I probably won't even claim monetization because it's good for brand awareness and making me more popular. Whereas specifically that squirrel video where nobody even knows that it comes from me necessarily. When somebody just reproduces it without licensing it, they're literally taking money out of my pocket to put into theirs under the guise of reaction or commentary when it is not necessarily legitimate fair use.
And I think that's the market usurpation factor, the fourth fair use factor.
Yeah. Nate, you go for it.
Well, no, just one thing. So at the end of the day, this incident seems to be a lot to do about nothing, because it seemed like this was like this predatory company going around. It's going to destroy us all from YouTube. But this really just seems to be a one-off event. They've had this relationship with this company. You know, you've been doing this, and it seems to have just been built up. And now it just got to the point where these people are saying, help. But I'm trying to understand MxR at the end of the day. It seems like they just want to still continue to use their Junkins copyrighted material under fair use and without being liable. And is that something that is, you know, I'm trying to understand, like, what's the end game for MxR plays, you know what I'm saying, for doing all this, because that's what we're talking about right now.
I think my assessment is that MxR wants to get out of the 6,000 that they think they are owed, and they want to get out of it without Jukin filing another 2 or 3. Well, I don't know how many more strikes they have left, but filing enough strikes to cancel their channel. And then they want to keep doing this and sort of set the precedent that if they spend a few hours looking for the copyright holder and they can't find them, then they get to do it for free, which I take issue with as well. And Leonard, you probably know the orphan works better than I do, but I don't think I don't know about better. But yeah. So I mean, my understanding is like looking for a few hours, especially in the digital age, is not what is meant by orphan works. Rather, orphan works are when the copyright holders are dead, you can't find the estate, or the photograph is so old it's impossible.
I would still call that part of the orphan works problem. And I was going to say, people have said that it's difficult to find videos on Jukin Media's website. I don't know how hard it is, or I mean, I don't even know how you would search for funny cat video, cat falls in pool, cat falls off cat post. That's got to be hard to find which video. Heck, I was looking for the one with the Spanish guy who has the funny laugh, and there's a million contagious laughter videos. How am I going to find that? Fortunately, it was a very popular video, and when I figured out, I don't know, the third set of keywords was Spanish contagious laughter guy, and he popped up right away.
Well, and to answer that, I mean, typically how you would do it is you would find they have the video, they know what they want to react to. Their issue is we can't tell if Jukin has it on their database. Right. We can't tell if Jukin owns the copyright.
There's no central registry of copyright.
Well, somebody owns the copyright to that video, presumably. I mean, I think it's too young to be an orphan work yet. Somebody owns the copyright.
True.
You go to YouTube, you find all of the versions where it's been ripped or unlawfully reproduced. You look for the original. You go to the original. Typically, with these video licensing agencies, they make everybody modify the description to specify who has the licensing rights. So you go to the original, you can find who has the licensing rights. If it's not there, I mean, you can do reverse image searches using a still image from the video. There are tons of ways to do a due diligence. Above and beyond that, but I think the issue is more that once they get notified, there's no action, and I think that's the issue. Like these agencies, I don't think they make their money off these types of fees or fines or sanctions for abuse. Right. They make the money off the business. This is just a way of protecting the business. So I think
I can speak from experience. I've licensed 2 of my videos to Viral Hog, and I'm currently in a dispute with them because there's one video that has like 14 million views and I haven't seen a cent, but that's a whole other story. But they go after the money, not the strikes and stuff. So I'm fine with that. I would prefer if they didn't take things down and rather just pursued the money.
Just a quick comment from Simos Funk. He says MxR says they do look through Junkins videos to pay licenses. So they say, and so these videos that they're talking about is things that they can't find, and then at the end they'll come back and say, okay, you have to pay us.
So either they need a blanket license, and they need a blanket license from presumably all the major providers, whoever they would be, or they need to be more diligent about providing more commentary and critique for each clip that they use to be within the fair use factors.
More commentary, more critique, more transformation, and as little as possible of the original in order to get the point across. I mean, it's the bottom line way to, in French we say trop fort passe pas. Too strong doesn't break. So you do all of that, but Oh, did we just lose Nate?
Yes, we did. We've taken
got
over
a
his
call.
channel. There he is, back. Yay.
Oh, we got a call. Okay, fine. No, sorry. So, I mean, that's the bottom line. It's like I don't know what their due diligence is. It depends on where they find the video to begin with, and then what they do to try to locate the copyright holder. But it's a question of erring on the side of caution. If it's not sufficiently transformative and they can't find the copyright holder, pick another video and avoid all of this headache. But
Yeah, I think the other thing that makes it difficult from a practical standpoint is that there seem to be a lot of people who are very happy to have their content shared around. And one thing that comes to mind is the epic rap battle people, because there are a lot of people doing reactions to their battles every time they have it. As far as I can tell, they have no problem with it, so don't seem to be having an issue with it. So this goes back to, like, there is a very sort of share and share alike culture on the internet, and a lot of people who don't mind when their content is shared, and then it's like trying to figure out who does and does not care, what clearances you do or do not need to get. It's very problematic. And for example, it can be difficult because I wanted to use music from somebody, and I sent them an email, and I never got any response back. Not that they had to respond to me, but like I have a sneaking suspicion that they don't care. But it'd be nice to be able to have that in writing before I used it. And it's like, I think a lot of people were like, well, they probably don't care. It's probably okay. And every once in a while it bites you,
And that's the way it should be. There should be some kind of middle ground there where I don't know how you would compel it, though. How can you compel parties to work together? But there should be something in between. Maybe we just have to reduce copyright damages to something more reasonable for more reasonable uses. Maybe the next Copyright Reformation Act, whatever that be, like the DMCA from 96 or whatever, maybe we make something that is more in the middle, so that when someone has a use case like this, that the damages fall somewhere in the middle. There is innocent infringement, by the way. There is, if you have looked for copyright ownership or registration or something, and you will be able to testify to that, substantially. There is a $200 number, and I've seen there was a case where someone basically, they won the copyright case but lost money because there had been what we call an offer of judgment on the table, and if you put the offer of judgment in early, then the attorney's fees are low, and if the total amount that you're offering is more than what they actually win plus the attorney's fees at the time, then you don't get the rest of the attorney's fees. So that was a $200 judgment against somebody who used a picture or something from the internet, plus only a few $100s in attorney's fees, and they made like a $1,000 offer of judgment or something. So they lost the case because they, lost on the copyright infringement, but because the damages were so low, the opposing side actually owed their attorney much more money than was paid out by the judgment.
Oh, wow. So now, because right now, like if you Google MxR plays, there's like this whole group of now YouTubers who are like belt in arms. We're going after junking. This is so wrong. This is so wrong. So, but I'm just trying to figure out, like right now, I'm just trying to figure out what, like, since you actually have two sides to the story, right? The evil corporation. But what do people want junking to do? Do they want them just not to do what they do, or like it's like, because that's what I was thinking before we even started the stream. Like, what the hell can junking do? If they don't do this, then they're violating the contract they have with the creators. But then if they do it, then you got this PR mess, And what do they want YouTube to do? It seems like they want. It seems like, from what I would understand, they want YouTube to kind of take away this aspect of, we allow people to do this and strike our channels, like, and take the channel down. So that's the piece that I think the YouTubers want, but I'm just not sure. I don't know if anybody has.
Did we go over why YouTube issues strikes as opposed to some other remedy or something?
Well, I think you mentioned it in your live stream that it's to ensure that they're not held personally liable or personally liable under the DMCA. So, I mean, I think I hope most content creators appreciate that. That's their sort of. It's not the same.
Yeah, it's not because YouTube is particularly mean. It's because we have cases like LiveJournal. We have cases like the ISP cases with Cox, where there was $1 billion judgment against Cox for not even they didn't share the music files. Their users shared the music files, but then Cox didn't take anybody down. They didn't. Now, what does Cox take down? What Cox does is instead, after you get so many undisputed strikes, they should be terminating your internet service. You should get several warnings, and then they should be terminated. How many warnings? Is it 3? 3 doesn't seem to be the actual magic number. Cox had a 13 strike policy, and then they still didn't disconnect people. And the judge said, hey, 13 strikes might even have been fine as long as you actually terminated somebody, but they didn't do that. So YouTube could probably choose a 5-strike policy or something instead, or maybe don't demonetize you on the first strike or something. Those are YouTube's decisions. But issuing strikes and then taking some and either terminating a channel or taking more drastic measures, that's required by the law in order to keep them in the safe harbor.
Well, so I mean, I don't know if it's legally statutorily possible, but I would think one of the things that would remedy this, or at least resolve the ambiguity, is before you give a strike, you wait for the dispute of the DMCA takedown to be resolved. So you have I think it's 10 days, Leonard, or guys, between.
Yeah, I think it's 10 or 14 days.
So,
yeah.
I mean, someone files a DMCA complaint before they can take it down, but before they give you the strike, just wait. If there's going to be a counter notice, wait for the resolution on the counter notice before issuing the strike. That would, at the very least, allow both parties to be heard before there's a sanction. I don't know why you couldn't do that.
They might actually do something like that. When I represented in the Imagos Softworks case, the Star Mazer DSP case, and Alex Maurer had our video game taken down from Steam, Steam actually contacted us and said, hey, if you just issue a DMCA counter notification, we won't take any action against you, and after 14 days, we'll put your video game back up. So they actually told us what we needed to do without even us having to figure it out.
I don't think YouTube offers that. I just, from my own experience, the only strike I ever got was actually for one of my own videos, because one of the licensing agencies who was licensing it accidentally issued a strike against my channel for carrying it where it was originally posted. But it was clearly an accident, resolved the same day. But I got the strike before I even had the opportunity to contest the takedown. So I don't think that they offer that.
If
but
they're still doing that, that makes sense.
that would resolve everything. I mean, what's funny in this is that it's I don't want to say like a class war. But it is sort of like two sides of the coin fighting each other. You have the reaction videos, all of their followers, and everybody who thinks if I can find it on YouTube, it should be public domain, and I want to be able to do what I want with it, versus other people who have created this stuff that say, it's not because I put it on YouTube that everybody else gets to use it however they want. And I think a lot of people are just misunderstanding fair use versus unfair use, or what would not be qualified as fair use. Yeah. And then just creating a false dichotomy that it's fair use or it's not. If it's not fair use, just pay for the license. I mean, that's the dichotomy, that the false dichotomy people are creating, and don't actually see the easy solution. Pay the $50 for the video if you want to avoid a problem. And if you don't, use another video. I mean, that would be the bottom line for me. Hating on Jukin, the only reason I would hate on Jukin is because of what they did in this. I don't know the exact order, but you have to know it's going to look bad publicly to do what you did. No one's going to understand the legal nuances, even if you're allowed to do it. And if you're not allowed to do it, it's going to blow up in your face even harder. But I would never have done what Jukin did. And I would never have advised them to do it. And this mess is sort of their own making, only to the extent that how do you expect the layperson to respond to 4 unsolicited invoices for $1,500 failing, which we're going to strike your channel out? I mean, nobody's going to.
And was that the actual threat? I still haven't seen. Do we know for sure that we've seen 100% of Jukin's actual threat, or did MxR just take the invoice and print out, or put up the invoice on the internet and say, "Oh my God, we received this," which is true, but maybe not the entire story.
Well, I base it only on Jukin's response, which didn't contradict certain facts, which if they weren't true, I probably would have clarified that they're not true. Like, no, we did not threaten to give you 3 simultaneous strikes to shut your channel down. Incidentally, opening up a parentheses, that's another big problem, is the triple jeopardy. Like, okay, let's just say I've done things, and I've done, because I have 1,500 videos, but I know that I haven't done it. But let's just say someone who's been putting up content for a year, they have 1,000 videos. If they've done the same mistake multiple times, I don't think it's fair to shut down the channel because they get 10 instantaneous.
We've seen that a couple times where somebody uses the same piece of music, and then that piece of music gets claimed 100 times.
No,
that's crazy.
Fortunately, those seem to get resolved fairly quickly as soon as someone becomes contrite and reaches out, and the whole internet blows up. And then about 4 hours later, people say, "Okay, it got resolved."
Yeah, and the only fringe benefit to that is by the time it gets resolved and the channel's back up, they've doubled in subscribers, because now people who have never heard of them. No,
But it shouldn't have to work like that. It should be much. We should be much more compassionate with each other.
Matter of fact, speaking
Get on my
of that,
soapbox.
I do want to ask you guys, how many emails or messages did you get about this thing? Because like I woke up and it was like MxR, check this out, this is crazy. I'm like,
Yeah.
what's going on?
Without getting into too many personal, my email, my DMs were blowing up, relatively speaking, but
Yeah.
they were blowing up, and I heard people email me talking about this injustice facing MxR, and I thought it was like a tiny channel. Like I thought someone was reaching out to me because I had the influence. And then I started looking into it, and I've already committed to making a response video. Then I look at they've got 800,000 subs on one channel, 2 million on the other. They dwarf me. So I said, well, geez, I didn't want anyone thinking I was just jumping on the bandwagon, but I had already committed to doing an expose. But
Everybody's got to eat. Come on.
What I love though is that that there are YouTube lawyers now that people immediately reach out to when there's it's very cool.
Yeah.
This is a really neat thing. One of my assistant was just saying, wouldn't it be neat if we could make a YouTube community where we all help each other and collaborate and try to protect people? And I'm like, I think we just did.
Yep.
No, that's exactly what I've been talking to Nate about a lot too. And it's like, I'd like to, my goal really here is to form more networks. So I'd love to get like a common Discord or some common forum where we can all, collaborate, and we can still, of course,
have a beautiful
have
one on the Lawful Masses Discord.
I love the fact that we're all talking to each other.
I'm on the Lawful Masses Discord too. So.
Excellent.
Yeah.
Would you guys believe if I told you that I've never been on a Discord and I actually still don't know what one is?
Do you know what Slack is?
I know what Slack is. Yeah.
Slack.
It's just like Slack, but maybe
Then
a little bit more aimed towards.
I never want to see it.
Okay.
It's like I hated Slack because I didn't need another source for emails or messages. Like I've got email.
People email me now about the trademark thing with the Hexbox, and I'm like, or they Discord me down, and I'm like, no, I need you on my email so I can triage it for my business.
It's too much. No, the one thing I like the idea of a community. I'm just totally neurotic about somebody suing me down the line because they think I gave them legal advice on an issue and it didn't pan out well because I'm from Quebec and they're from,
I don't want to get ahead of ourselves, but Lawful Masses, I do need to do something about my student loans. And so here's my thinking. The student loans, in my case, I don't know about anybody else, but my case, I have a public service student loan forgiveness program. So what I was thinking, we've been thinking about this for a while now, a couple of years now. I'm just scared, like you said. What happens if I do it wrong or something? But if we make it into some kind of public legal service nonprofit or charity or something recognized by the IRS and fully above board with board members. I already have a former Google employee who wants to be on the board, and we're building a very good, very trustworthy relationship with this person and others. And if we turn this into something, it could be my career, and other people could. It could be their career or their partial participation or whatever you want, and we could all help the smaller problems that we see that can't be serviced by because people don't always often have the resources to pursue these things, and I call it an access to justice problem, and it's a weird thing because we never thought of an access to justice problem on YouTube with copyright, but it seems to be. There's so many illegitimate claims, really real extortion threats, and other just problems with YouTube. And how do people get information? They don't even want to contact an attorney because they think they're going to get a massive bill. And so I'd like to dispel some of those myths and take it to the next level.
So it's very interesting. I mean, I was thinking YouTube could do well to have some sort of representative, not for YouTube, but rather to represent content creators who face these issues, and a representative that doesn't answer to YouTube, but that could be potentially financed or subsidized by YouTube so that people could get answers to questions and then know how to deal with their problems.
Yeah. And it's apparently corporations like to make donations too, to look good. Just
charities. Oh yeah, especially the 501c3s. Yeah, definitely. I think that would actually work because the loan forgiveness, but then because you have to work for the 501c3, you'd have to work for the charity.
It has to be minimum wage, 35 hours a week, I believe, is the requirement.
Leonard,
I'm perfectly willing to commit to that.
What law school did you go to, Leonard?
Widener University in Harrisburg, a 4th tier ABA accredited law school.
Okay. I was thinking, I went to this place called Université Laval in Quebec City, and I didn't come out with student debt because it was $1,800 a semester, and
we hate you.
Life in Quebec. I have a brother who went to MIT, and I have some I have siblings who went to the U.S. universities. It's just like it's a totally different world.
I'm about to block your ass now if you got no student loan debt from law school. No, it's funny. No, I got a free ride in law school, and I still have like 90,000 because I couldn't work. It was like you had to go full time.
Yeah.
So
the
they get
2008 crash happened during mine.
Oh, so oh my God, that was.
I didn't even have work for the first couple of years.
Oh my God, yeah, and now they've changed the whole student loan debt forgiveness now, where if you're like off for one payment, you got to catch up before they start. It's really crazy now.
What we definitely need for like the four of us and whoever else is in on this, we need some sort of common messaging app so we can group message each other. That's text message or Facebook or something. But I don't want to keep messaging each other.
I veto Facebook Messenger.
Slack, we gotta get on Slack.
I'm even happy to just have like a common email thread going or something.
There you go.
Leonard, has anybody heard from MRX directly? Like Leonard, you seem to have got in like early.
Let's see. It's not confidential information for me to do the canary and say that I have not heard from MxR. But if I did and it was confidential information, I wouldn't be able to say that, right?
Damn it! You know what? I should have known better than to ask that question.
Actually, but the hang on. No, this is a good ethical question. Is the fact that you represent someone, is that I don't think that's confidential information in most U.S. states.
I don't know. I think in litigation, obviously not. But I think if someone is a client, it is confidential to the extent that it is not already publicly known.
Okay.
Which makes
if the thing is, I would go with your rule, even if I knew the rule was the other way, I'd still be like, I'm not going to say anything publicly until my client says it's okay. I wouldn't want to tick off my.
No, true. And
I think that's always the best way to go.
I haven't been contacted by MxR, so not me.
I was only thinking as a YouTube content creator, not as a lawyer, because I mean, I have two things. I would love to do a live stream with Jukin because I'd love to get clear on the fact pattern, and I'd love to hear what they have to say, and allow them to respond in a way that's more effective than coming off social media and posting tweets. And I would also love to speak with MRX because this is something that is not cut and dry. Everybody who just says, "No, Viva Frei, you ever heard of fair use?" does not understand fair use adequately, because this is not cut and dry fair use. It is arguable, and depending on the videos, it's more or less arguable. And even in the decision, like the equity 3, whatever,
equals 3,
equals 3, even in equals 3, they set the precedent was, it's very unclear. 3 of the 4 were fair use, 1 wasn't. It depends on the transformative aspect, even in commentary. So anybody who purports that this is cut and dry is not understanding the nuances. But this is like this could be a learning lesson for content creators and for viral video licensing agencies, because they are not properly understood on the market, and they are seen as vampires as opposed to I don't know what's the opposite of a vampire, but they're seen as vampires, bloodsuckers, as opposed to companies.
Me after Italian.
Hey, but what was I going to say after you know what? Forget about it. I just totally lost my thought. I hate when that happens. It's my lawyer brain too.
Oh, I do that too.
It's like I had something I was going to say and then leave it to that last sentence, and it just like went away. Shit, it must have not been important. But so at the end of the day, I think. At the end of the day, I think this copyright issue, I think it's hopefully should be settled. Hopefully they'll work together. But I think Jukin's going to take a hit definitely in the PR category. Their stock must be fucking tanking or something if they have publicly traded, because people are definitely going to be running from them. But I really don't see anything they did wrong except for the $1,500 fine. I think that's a little $1,500 invoice. I think that's a little ridiculous. But again, that's their business model, so that is what it is for them.
Well, the funny thing is, like, you think these big corporations have this protocol, and you think big corporations are like these amazing entities, but they're only as competent as whatever individual is representing them at the time. And this is a mess, not from a legal perspective, but just from how it was handled perspective. But you don't know. And the thing is, it's easy for one person, it's one party, to go public first, tell their side of the story, and then set the playing field sort of for the rest of the world to view from that perspective. But we don't know enough of the facts in terms of what the timeline specifically was with Jukin. You can only decipher that from MxR's own admissions in their own video. But it's the reaction genre is gray zone, and people should be sensitive to the risks and also to the various interests. It's like when someone does a reaction video and makes money off of it and takes someone else's work a substantial portion of it. They're making money and taking money out of someone else's pocket, even if it's, dollars and cents.
It does feel like that. Although I still like to say that copyright infringement is not stealing. I'm not saying that it's not very much like stealing, but it's also called copyright infringement and not stealing for a reason.
Mm-hmm.
I mean, we can non-legally call it stealing, and I even see stealing or theft being used in plaintiffs' briefs all the time for copyright infringement, but it is not considered the same exact thing as theft because it has extra characteristics to it.
No question about that. The difference between stealing and unlawful acquisition of proceeds from.
Now you're talking like an attorney, right?
We're walking that fine line now.
Someone is making money. Someone is making money off someone else's work, and in the process, not allowing that person to be remunerated for their work while the other person is making money off of it. There are diverging interests that need to be reconciled or at least respected.
Unjust enrichment. Yeah.
Unjust
enrichment. Oh my God, it's bringing me back.
I got to go see the
contract.
The Quartering just put up another video, I think, a follow-up saying Jukin was on the run and
some of those they're the king of clickbaity titles sometimes. I mean, you even called me out on the the trolley. Did the troll really play itself?
Oh, I felt like I had to click that one. I was like, what
that was a great
troll. What? He got me.
I'm going back to the French expression "bon dull," or someone gave me a good translation called "puffery." But yeah, everyone knows your title. The title has to be interesting. I just think in that particular judgment, it's true that Jukin says, here, look at this judgment, and it's not 100% in their favor.
Yeah.
It's not 100% in the other.
It sort of describes what you need to do to stay out of there.
Well, exactly. And it sort of describes what Jukin ought to have hopefully did this time around. Yeah. Hopefully they registered the copyright. But just to make sure I understand that one spot, you said you won't even survive a motion to dismiss at the federal level if you haven't registered and obtained the certificate for copyright.
Now but hold on, that's new though, right? Because it wasn't
Fourth Estate Public Benefit Corporation. That's a 2019 Supreme Court case.
Oh, all right. Because I was about to say, I was like, hold on, that's the first time I've ever heard about that. But that's really new.
So that changes the whole game for Jukin, who now cannot sue even if there was a reason to sue until they get those registrations. And if they don't already have the registrations, which I haven't actually done it yet. I need to go on copyright.gov and look for what Jukin Media has registered. If they haven't registered those things, then they've got an uphill battle before they can even get there. But they can still issue DMCA takedowns and make monetization claims on YouTube and take everybody off while they're on their way.
But that's to say then, I mean, they can't sue for any reason, for any monetary basis whatsoever, or they can only not sue for statutory damages.
I believe they can't even file a lawsuit that would survive a motion to dismiss.
Oh, but hold on.
What was the Gigi Hadid case that Gigi Hadid got her photo taken or something by a paparazzi, and the paparazzi, she posted the picture or something, and they sued her for it. And I said, there's no way that she's going to win. And then she won because Fourth Estate Public Benefit Corporation was ruled on and then immediately kicked her case out on a motion to dismiss.
But hold on, so I want to ask this, because from what I'm understanding with the YouTube, with the whole DMCA policy, let's say you get the copyright strike, you challenge it. Okay, I'm challenging it, and then YouTube says, from my understanding, that then you have to go and actually file a lawsuit and show it back to them to go the next step.
Yeah, there's a weird thing going on in there too.
So
YouTube is often not honoring the counter notification process. So what are the damages there? But please continue.
But so let's say that happens and they say, okay, now since somebody's done the counter notification, you now have to go file your lawsuit. You do go file your lawsuit, but then if you haven't registered the copyrights, you got nothing, right?
Yeah. How do you file a lawsuit? Well, they could file it, and the DMCA section 512, I forget which section, I think it's G. I forget what the takedown, the notice and takedown section says that once a counter notification's filed and then the person goes to court, then they just have to show the provider proof of that court action, not actually show the results of the court action. But I still think this puts us in a really weird gray area of the law, since you must have had your copyright applied for 6 months ago if you wanted to sue today for something that happened today.
Yeah, because what it does, it almost makes it impossible. Where now, if the counter notification, you sue me, then I can just motion to dismiss if it's not registered. In other words, it almost makes it impossible for the copyright owner, unless it's registered, to actually do anything on YouTube, because you can actually fight that back, right?
Yeah, and I'm going to say the most absurd thing you guys have ever heard. This is why it's important to not vote for idiots.
Well, okay, now, but I just want to make sure I'm going to nail this because I want to make sure I understand it. It is registration of copyright now in virtue of this 2019 decision in the United States is not just a question of providing evidence of ownership as of a certain date. It's a prerequisite to sue for any and all damages, not just
I'll go back and need to clarify if there's any circumstance whatsoever. But my understanding was at least suing for money damages, and I think injunctive relief as well was in there. You need to have the registration received back from the Copyright Registration Office, which is about a 6-month process. And I believe the court even said, yes, this is a difficult result, but we as a court just interpret the law, and the law clearly says that you have to have a registration before you sue, and that the language is rendered meaningless if you only need an application. All
right, so you're talking about 6 months. So just looking at the process, so now 3-year statute of limitations. So that means you actually only have 2.5 years because if you don't,
yeah, sort of,
yeah, because if you let's say if you don't have it, then you have, if you don't file within 2.5, if you don't register within 2.5 years, and somebody, then you're screwed.
We are skipping one thing. There is an $800 filing fee for an expedited copyright registration for the purposes of suing. That only takes about a week or so.
Well, now you're making me
That's one
I'm going to have to check under Canadian law now to see if there hasn't been a change subsequent to this, because I mean, typically
this is crazy.
You registered so that you could have proof of creation, proof of ownership, proof of dates, so that you could more easily claim statutory damages. But now, if registration of copyright is just a prerequisite to suing for statutory and or real damages,
yeah,
I mean that's okay. Well, I mean that may be a bar to Jukin's threats in the first place, and in which case, then they may not have legal recourse; they'll just have statutory recourse.
Yeah. Now, they still have all the legal rights to make those demands and claims and things, so it doesn't actually undo their underlying case. I think it just makes it plays out differently than I think we all thought it would if they decided to pursue it. So in other words, so we're having all this wonderful discussion right now, and they can't just go to court and file something and then say, hey, look, here's the paper, while everyone's still in the middle of the controversy. We'll hear about it 6 months from now, and we'll all go, who?
Yeah.
Well, oh my God. So at the end of one thing I want to shift to is that COPPA.
Okay.
That's the next bomb that hit YouTube. So we got this, and then we have COPPA.
Call it the COPPA chameleon.
The COPPA chameleon. So with COPPA now it seems like it's funny because my daughter loves YouTube too. And all those channels now have, you can't do this, you can't do this. And one guy was showing his analytics. In other words, he made like $10,000 a month, and it went down to like $10 a month. Like it was like that bad. And even on his older videos, he's just lost so much money. So now it's funny because I think YouTube is now becoming a place where if you're too edgy, adult content, you get demonetized. You can't do that. And now you can't do family-friendly content because you get demonetized on it. And so where the hell do you go? What the hell do you do?
I feel kind of bad because the law, the COPPA has been on the books for 2 decades, and YouTube was more or less flaunting it. Well, Google was more or less flaunting it. And then suddenly in the beginning of September, it's like, well, we're getting sued by the FTC, but like they contacted us before and we settled it all. So they're going to file the thing today, and we're going to pay a settlement today, and the judgment is entered today, and it's all done and over with already. But now you YouTubers, you all have to deal with it.
Well, only thing they did, and for everyone, only thing that settlement did was just shift the onus from YouTube to the creators, because that actual knowledge requirement, YouTube, for everybody who doesn't know, and for COPPA, there's an actual knowledge requirement for platforms like YouTube. They have to have actual knowledge that content is child directed for them to be fined, and the government was able to show that they had actual knowledge. So to kind of protect YouTube, that's why they ask everybody, is your content child directed? So if you say no, they can say, hey, we had no actual knowledge because you told us, you certified no. So that whole settlement was just to protect YouTube. But now, what about content creators? Because now, that's a big question I usually get now is just like, shit, what kind of content can we curate? Because we can't create something that's family friendly. We can't collect. So, where where's the middle ground here?
Well, I still think the answer is like mixed audiences. I guess the answer is PG-13 is the answer, is what you can produce. That and late night comedy. It's like, that was sort of what I was saying earlier, is everyone's fears that this is just going to turn into late night with whomever, corporate media again. But I think the practical answer is, general audience, mixed audience, all ages kind of content. So, the way the statute reads is, first of all, if it applies at all, which I still maintain, I don't think it really does. But if it applies at all, it only it applies to content that is directed to children.
Yeah.
As targeting children. So unless you're Peppa Pig at all, I don't think
Lawyer shark
not a lot of
shark
under 13-year-olds who are watching a lot of law blogs, I think. So it's probably okay.
Well, the let's call it the conspiratorial person could think that this is a deliberate sort of sequence of events between big corp and government, so that you could just turn YouTube into the next television and then have another platform worry about the issues. But the one thing I never understood is why just having a kids dedicated platform wouldn't be the solution. And then everybody, whoever wants to market for kids would go to the kids platform. They'll use contextual ads and not targeted ads, which will be pretty much just as effective. Like with these targeted ads everybody talks about, in my entire life, not only have I never clicked on an ad, I've never bought anything that came by way of targeted ad based on my
you're missing out. It's a great ecosystem. I just love the ads that you get after you buy a bed and they want to sell you 10 more beds.
Yeah. Oh my God.
I don't think I've ever bought anything off the internet that way, but like, if they were to just create the separate platform where everybody knows that platform is YouTube Kids, directed at kids, they know what they can collect and what they can't, and the contextualized ads would have a greater value, maybe less than targeted, but there's still the market to advertise to that demographic.
But isn't that how YouTube got burnt before? They got burnt by YouTube Kids because they were saying that, that was the actual knowledge that, hey,
that was one of the apocalypses.
Yeah, it was like, hey, YouTube Kids, we'll put, but they left the child-directed content on
videos.
YouTube. Yeah, and so.
Well, and Spider-Man get romantic.
Well, and the other issue, I don't know who's going to challenge the constitutionality of it, but whether or not the persistent
YouTube,
identifiers, like whether or not the persistent identifiers for targeted ads was the data that people were afraid that was being collected on kids when COPPA was first instated. I mean, I would argue it's not, but who's going to take that lawsuit, and what are the chances of it succeeding?
Well, but the two things though, and UnCivil law, he understands it's 100%. That's the bit when you're dealing with administrative law, the Supreme Court precedent of our, because we're really talking, even though we have COPPA, we're really talking about the regulation, the Children's Online Privacy Protection Rule. And there's a Supreme Court precedent of our that says, they're going to defer that, to the agency's interpretation of their own regulation. So not only do they get to write the law, they get to interpret what the hell it means for us. And that's kind of
that's a cop out.
That's but that's ours.
Wow.
Explain it to him, Blackleaf.
Yeah, unfortunately, he's right. The case called Auer, it's AUER is how it's spelled. It is a parallel case to Chevron. So Chevron said that regulatory agencies get to interpret statutes that apply to them. Auer says that they get to interpret their own regulations that they wrote. So not only do they get the power to write the regulations based on their interpretation of the statute, but they also get the power to interpret their own regulations, which I find is just hilarious and horrible, but it's the law. So, yeah, when the FTC is saying things like, well, this statute says we can go after individual content creators because they are, what was the language of the statute?
Operators.
Yes, operators is the magic word. Thank you. Because they're operators. And I look at the statute, I'm like, I'm not so sure. But yeah, he's right. The counter argument from the FTC is this case called Auer. It's like, well, we wrote the regulation. We know what it means. And even though we changed our mind, we're still right because magic.
So get it. Who would be interested enough to lobby to have the government just legislate new laws or new powers to the FCC?
No, but you'd have to go.
I thought about suing for declaratory relief. I was talking to people. I was like, maybe I'll just file for declaratory relief in January and sue the FTC and see how that goes.
It would make for great content.
But you would have to have some child-directed content, right? Because they can tell you have no.
I'll even put cartoons in it. So I'll make it real child-directed too. That'd be good.
No, but it is sort of crazy. I mean, we would be able to challenge the constitutionality of it. We have sort of deference to the administrative tribunals in Canada as well, but you could you could challenge the constitutionality and the scope of the legislation and the regulation. But it is crazy. It's that the idea that certain things that were never what was intended to be governed by the actual law and now are included to the point where it's changing what the internet was and what YouTube was.
Well, the hours getting the deference is hours getting it's getting chopped down a little bit, right? What was the case, Blackleaf?
I can't remember the case off the top of my head, but there was a case, I believe 2019 term, where they thought they might kill Hour. They didn't go so far as killing it, but they did put it a little bit more in life support. So that's why I'm saying, Blackleaf could file declaratory relief against the FTC. Blackleaf's admitted to practice before the U.S. Supreme Court, so I can go pro se it, and I can get this case killed myself.
Put out a tweet. If this tweet gets 1 million retweets, Blackleaf is
Yeah. Blackleaf kills Hour. Good times.
All right. Well, listen, guys, we've been at this for about an hour 40. Well, me and Blackleaf, you guys came in late, but
I got the easy. So you got the easy.
Nate, this was the greatest. This was the greatest impromptu 4-way.
I love it. I love it.
I messaged I made the joke in the stream, and then Nate sends me the link, and they say, "Hey, let's get Leonard French on here," and it's magic. It's magic.
It is. It's awesome.
We definitely have to do this again, though. Some people call it what's it called, the Four Horsemen or something like that.
The apocalypse. We'll be the Four Horsemen of the adpocalypse.
Well, but I would think maybe in the impeachment and the whether or not Trump's been impeached and the validity of withholding the articles, that would make for a good topic.
Oh yeah. Well, it'll be wild. That supposedly that's the next thing. So and then we'll be getting calls. Can you believe what they did? Can you believe what they did? Like, no, I don't know.
Nate, when you told me this when we talked yesterday, it reminded me I got to go reactivate my MMA after. What was it? Viva MMA. Because I at one point I started an MMA sort of Viva channel, and I'm gonna have to go revive it. And with McGregor fighting Cowboy Cerrone this Saturday, it might be the perfect opportunity.
I can't wait to watch that.
It's going to be epic. Who's picking who? Leonard, you don't look necessarily like you're into the UFC.
No. Sorry, I don't.
UnCivil Law. Are you familiar with UFC?
I watch a lot of it, but not enough to pick favorites.
Okay, well,
every time I pick McGregor, he's losing, so I'm picking the other guy.
But
he's lost like the last two fights.
Are playing tonight. I'm picking my Clemson Tigers to win the national championship.
I'm picking Clemson with you because I know you love, even though I believe LSU is going to kick their butt. Clemson, baby.
Yeah.
So who do you think? Who do you think?
8 o'clock.
Huh? I always pick a loser, but I think Cerrone. I'm picking Cerrone this time.
I think Cerrone's going to win, but I don't know. McGregor's just too much. I
think Cerrone's going to win. He's going to use it to get another title shot, and he's going to be the belt holder.
Can I vote for Logan Paul?
Oh, you know what? I love those fights though. Like even though those fights are so cheesy, I'll spend the $10 and watch them because they're so entertaining.
It was surprisingly high quality. Their fight. It wasn't as bad as I was expecting it to be.
He got robbed the last fight. I don't know if you guys saw the last fight. Logan Paul got robbed. He got robbed. Come on, French. You don't think he got robbed?
I didn't see it.
You gotta watch.
Well, I will definitely make sure to tune into the next UFC so that after whatever happens, I can blow up the text messages with whatever.
All right, listen, guys. I will see you guys later. Thank you. I'm about to cut the stream off for all you people in the side chat, but thank you guys for stopping by, and thank everybody for who's watching. My name is Nate. Viva Frei, UnCivil Law, Leonard French. We all thank you for watching, and we'll be talking to you soon. Later.
Thank you.
I'm ending broadcast.